Hello, everyone. Today is our lesson on employment law. Now, there's a lot to learn about employment law, but because this is just a single lesson, we're just going to hit some of the high points regarding employment law. Okay, so first is the employment at will doctrine. So, employers can terminate an at will employee with or without advance notice and with or without just cause. But there are certain exceptions. So, if you're an at will employee, you can be terminated. Doesn't need to be a reason, it can be without advance notice, but if certain exceptions apply, then the employment at will doctrine doesn't apply and you can't just be fired willy-nilly. So here are the three exceptions to be aware of. The employee has an express contract, courts have fashioned a common law exception, or there's some kind of statutory protection. So let's look at that. First, we'll talk about express contract, which is one of the exceptions to the at will doctrine. So when the parties enter into an employment contract, the termination terms are spelled out in the contract. So if you enter into an express contract, which requires you to, let's say, miss, that would be a problem, to meet deadlines for your projects that you're working on, you can be fired for poor performance because you did not adhere to the contractual obligations that you had. If you have excessive absences, if you threaten violence, these may be violations of your express contract and therefore you can be terminated. So there has to be typically under these employment contracts good cause, such as, some of these examples we looked at could be a criminal act in the course of your employment. So second, reason why the employment at will doctrine would not apply is if there's common law exceptions. So what are these common law exceptions? So there's three of them listed here. We'll take you through each of these three: implied contract, so not an express contract, which we talked about before, but an implied contract, some kind of public policy exception, or the covenant of good faith and fair dealing. So what does that mean? Implied contract. So the employer acts in a manner that would lead a reasonable person to believe that the employer intended to offer the employee protection from termination without cause. So there's no actual express contract in place, but it is implied based on the circumstances. Now, what might that look like? So let's say, for example, there is a manual, an employee type of handbook or manual, and it's distributed by the employer to the employees within the company. And it extends some protection. So it does protect these employees in certain circumstances. So let's say there's some kind of three strikes and you're out rule in the employee handbook. So this may be construed as an implied contractual promise of continued employment. So if, let's say, you do something that is in violation of the manual, but there is some kind of three strikes rule in the manual, it looks to be an implied contract, and there may be this implied promise of continued employment because there was only one strike. Okay, the next circumstance that may give rise to an implied contract is an oral promise. So let's say the employer verbally promised you that you could always work there as long as you perform well, right? A reasonable person may believe that that promise does extend protection against termination without cause. Okay, so this is implied contract. Public policy exception. So narrowly applied, that places the public welfare ahead of the rights of an employer. So, in this kind of example, let's just say, let's look at these pictures. So, there's this work injury compensation claim form. So, let's say a worker files a workers' compensation claim after being injured on the job, and they are fired because of that. So this looks like it would be falling into the public policy exception, and there could be a problem with termination because of that, even if they were an at-will employee to begin with. So let's say a person is performing their civic duties, right? They receive a jury duty summons. They need to appear in court as a witness, and they're fired because of that public policy exception. This picture here, what does this look like? Maybe the boss in the company is doing something illegal, right? And the employee is reporting those illegal activities, which is called whistleblowing. That again is a public policy exception to the employee at will doctrine. Now, what is happening in this picture? Let's say right here there is a bartender, and the boss of the bar is telling the bartender, you can go ahead and serve these people, even though they're underage, you can serve them. And this employee, being the rule follower that she is, refuses these unlawful requests from her employer. She refuses to serve alcohol to a minor, and she is fired because of it. So the termination in these cases is inconsistent with the general public's well-being, and it falls under the public policy exception. Covenant of good faith and fair dealing, adopted by the minority of states. And the states will look at the job termination and see, was it without just cause? Was it in bad faith or with malicious intent? It's very broad in coverage. And your book gives an example on page 372 where a sales rep was involved in negotiations for a large sale for his company. And he was fired without cause 2 weeks before the sale was supposed to close. And the company denied him commission. So in that case, it looks like there could have been this violation of good faith and fair dealing. And that may have been an issue, even though he would have otherwise been an at-will employee. Statutory exceptions. So certain statutes displace common law employment at will rules. Anti-discrimination laws, which we will look at in a bit more detail, prohibit termination and other workplace actions based on certain discriminatory motivations. So we have to see what would a discriminatory motivation look like, race or gender. Those are a couple examples here. There are other statutes as well that prohibit employers from terminating employees for certain reasons, such as being absent due to jury duty or attempting to form a union. We looked at, jury duty and attending jury duty as, public policy exception if someone is terminated because of that. So there's definitely some overlap here with the statutory exceptions. Okay, whistleblower statutes. So, what is a whistleblower? An employee or an agent who reports unlawful conduct or a statutory violation by their employer to the authorities. So, let's say someone is an employee and they are reporting unsafe work conditions to their boss and they're terminated for raising the issue, or they report unsafe work conditions to an administrative agency and it's discovered by the employer and they're terminating for raising the issue. So generally, employers can't terminate employees for making a report to the authorities, being that whistleblower about the employer's conduct. But there is this defense that the employer could bring. They can terminate employees who are whistleblowers if the employer can also show that they terminated the employer for reasons that are separate and independent of any whistleblowing. So during the litigation, the case, the discovery, they'll try to pull information to show that the actual reason that they terminated the employee was separate and independent from the whistleblowing. So this case from 2016, and it was out of Pennsylvania, was brought by an assistant football coach at Penn State against Penn State. So a grand jury investigation took place related to the sexual abuse of children by a Penn State employee and the subsequent cover-up by Penn State. So this grand jury investigation was released, and this assistant football coach, McQueary, was brought to a meeting and he was told that he was going to be placed on administrative leave, banned from all facilities, required to turn his keys, cell phone, and other university property. And he learned also after that that he had been officially terminated. So what he does is he files a claim under the Pennsylvania Whistleblower Act, and he alleged that Penn State had fired him after they discovered that he had actually provided testimony to the grand jury in their investigation about witnessing the sexual abuse of a minor by Penn State football coach Jerry Sandusky. He testified that he told the head football coach, Penn State athletic director, and the vice president for administration about the incident. And the grand jury charged Sandusky and two of those other individuals with various criminal offenses related to sexual abuse of minors and failing to report it to authorities. So Penn State, in receiving this lawsuit brought by McQueary, defended this whistleblower claim by alleging that McQueary was an employee at will, so they could fire him for whatever reason they wanted. And they said that his appointment was not renewed after the new incoming head football coach determined there was no room for him to continue as part of the team's new coaching staff. Okay, so they said, he's an employee at will, and we didn't even terminate him because of that. It was because there was no need for him. So what did the court rule? They ruled in favor of McQueary on this whistleblower statute claim. And they awarded him $5 million in damages under that act, plus an additional $1.7 million in legal fees, holding that his good faith reporting of the sexual abuse to his supervisors qualified under the statute as a protected act of whistleblowing. And under the Whistleblower Act, the burden then shifts from him to Penn State to prove that the termination was for separate and legitimate reasons. Sound familiar? We talked about that. Separate and legitimate reasons from any whistleblowing activity. So Penn State contended that his termination was unrelated to his grand jury testimony and was the result of routine personnel changes and a new incoming head coach. So they were claiming it was for separate and legitimate reasons. But the court pointed to evidence that the new head coach had never even interviewed McQueary and had never looked at his personnel file, and that the decision to fire him was contemporaneous, took place at the same time when the administrators found out about his grand jury testimony. So anti-discrimination statutes are the largest category of statutes that prohibit employers from terminating employees. And employment discrimination as a term encompasses workplace-related discrimination, including various things: the hiring process, the treatment of employees. So it could be demotions, it could be promotions, work schedules, working conditions, assignments, disciplinary actions such as termination, suspension, and reprimands. So claims for employment discrimination can be brought, and it could be based on these different types of situations. So the EEOC, it's an important administrative agency to be aware of in the realm of employment law. And this agency is charged with carrying out federal workplace anti-discrimination laws. They play two very important roles when it has to do with protecting people from discrimination. So a complaint can be filed with the EEOC as the first step for a party that's claiming to be a victim of unlawful discrimination. And in some cases, the EEOC will sue on behalf of the aggrieved employee or the alleged victim. Title VII of the Civil Rights Act of 1964. So this applies to private sector employees with 15 or more full-time employees. You can see the rest there. It covers hiring, firing, promotion, demotion, disciplinary actions, work schedule, pay rate. You can read the rest. So similar to what we saw on the last slide. So it covers a lot of what we talk about with regard to employment discrimination. And it prohibits discrimination in the workplace based on the employee's race, color, national origin, gender, or religion. So these are referred to as protected classes. And in 1978, Title VII was amended to specifically add pregnancy as a protected class. And case law has, over time, helped define what these different protected classes are and who they include beyond what it looks like based on the plain language of the statute. So not all discrimination is illegal. So Statutory protection is extended only to those who are members of a protected class. It has to be based on their membership in a protected class. The plaintiff doesn't need to be a minority within the protected class to be covered by Title VII. So discrimination against a member of a dominant or majority group within the protected class can also be the basis of an employment discrimination claim. So sexual orientation as a protected class. So the EEOC in 2015 issued a ruling that recognized discrimination based on sexual orientation as a form of sex discrimination. So what they said in their reasoning is that sexual orientation is a sex-based consideration. So we know that that gender is a protected class, and an allegation of discrimination based on sexual orientation is necessarily an allegation of sex discrimination under Title VII. So there is a very well-known U.S. Supreme Court case called Bostock versus Clayton County. And this case was decided in 2020. And the Supreme Court in this case ruled that an employer who fires an individual merely for being gay or transgender violates Title VII. So that is deemed sexual discrimination. So here, let's take a look at this video regarding that case.
The Civil Rights Act of 1964 changed American discrimination law forever. It prohibits employers from discriminating on the basis of race, color, religion, sex, or national origin. But does it protect homosexual and transgender individuals? The United States Supreme Court considered that question in Bostock versus Clayton County. Gerald Bostock worked for 10 years as a child welfare advocate for Clayton County, Georgia. Shortly after Bostock started playing in a gay softball league, the county fired him for conduct unbecoming a county employee. Bostock sued in federal court for sex discrimination under Title VII of the 1964 Civil Rights Act. The district court dismissed his claim, and the 11th Circuit affirmed, ruling that Title VII didn't prohibit discharge for homosexuality. The Supreme Court granted Bostock's cert petition and joined his case with that of Donald Zarda, a skydiving instructor fired a few days after mentioning he was gay, and Amy Stevens, a transgender woman who'd worked for years as a man for a Michigan funeral home, but was fired after informing her employer that she intended to live and work as a woman. Both the Second Circuit in Zarda's case and the Sixth Circuit in Stevens's case ruled that Title VII did prohibit employers from discharging employees for homosexuality or transsexuality. The court considered whether Title VII protects homosexual and transgender individuals from workplace discrimination. The court answered yes, that Title VII protects homosexual and transgender individuals from workplace discrimination. Justice Gorsuch, writing for a six-justice majority, explained that, in pertinent part, Title VII of the 1964 Civil Rights Act makes it unlawful to discriminate against any job applicant or employee, quote, because of such individual's sex, unquote. Gorsuch explained that because of sex translates to but-for causation. But-for causation is established whenever a particular outcome wouldn't have happened but for the purported cause. So a Title VII defendant can't avoid liability by citing some other factor that contributed to the challenged decision. If a plaintiff's sex was one but-for cause of that decision, Title VII is triggered. When an employer fires an employee because the employee is homosexual or transgender, two causal factors are in play, both the employee's sex and either the sex to which the employee is attracted or with which the employee identifies. But the employee's sex is unavoidably part of the employer's decision, and that's what Title VII specifically prohibits. Gorsuch offered two examples. He postulated an employer with two employees, a man and a woman, both of whom are attracted to men, and both of whom are competent employees. If the employer fires the man solely because he's attracted to men, a trait the employer accepts in his female employee, the employer is discriminating solely on the basis of the employee's sex. Likewise, if an employer fires a transgender person who was identified as a male at birth but now identifies as a female, while retaining a female employee who has identified as female since birth, the employer is firing the transgender individual for now identifying as female, a trait the employer accepts in the other employee. Again, the only difference is the sex to which the employee was first assigned. In response to dissenters, Gorsuch acknowledged that Title VII might possibly reach farther than its drafters in 1964 anticipated. But when applied to these cases, the statute's plain language can brook no other resolution. The court concluded that the plaintiffs in all three cases properly accused their employers of violating Title VII. The court reversed the 11th Circuit in Bostock's case and affirmed the 2nd and 6th Circuits in Zarda and Stevens's cases. Justice Alito dissented, arguing that Congress has for many years considered but failed to pass bills to add sexual orientation or gender identity to Title VII's list of protected categories. That Congress has considered adding these categories means that Congress doesn't believe that Title VII currently protects them. By ruling that Title VII does protect them, the court is legislating from the bench. Justice Kavanaugh also dissented, arguing that the question of whether to add sexual orientation and gender identity to Title VII rests with Congress and the President, not the court. Bostock v. Clayton County will expand the reach of Title VII to protect many more individuals from workplace discrimination.
So here you can see the decision and the opinion of the U.S. Supreme Court in the Bostock case as mentioned in the video. Supreme Court ruling that an employer who fires an individual merely for being gay or transgender violates Title VII. And you can see the rest here as referenced in the video. So sexual harassment in the workplace is also an issue we should be aware of. There are two types of sexual harassment that can occur in the workplace. One is called quid pro quo, and one is hostile work environment. And I'd like to show you a video that helps us understand these.
Sexual harassment can be broken down into two types: quid pro quo and hostile work environment. Quid pro quo. Quid pro quo is Latin for this for that. In the workplace, quid pro quo sexual harassment occurs when an employee of higher rank, such as a manager or supervisor, bases workplace decisions such as promotions, advances, or bonuses on what another employee, usually of lower rank, can give him or her in exchange. This is typically sexual favors or similar. Let's look at an example of quid pro quo sexual harassment. Anne is long overdue for a promotion. Tom, her manager, hints that he can make things move faster if she goes out on a date with him. In this case, quid pro quo sexual harassment occurs if Anne refuses Tom's advances, after which he gives her a bad evaluation at the end of the quarter, costing her the promotion. Or Anne agrees to go out with Tom because she badly needs the promotion and raise or doesn't want to risk retaliation. So basically, the harassment is also recognized if an employee gives in to avoid some detriment, such as being demoted or fired. For the most part, quid pro quo type of harassment thrives on the element of power. The harasser, being a manager or supervisor, takes advantage of the fact that he or she can give out benefits such as a raise, better shift hours, or a promotion. The victim, on the other hand, fears the negative consequences that might follow if they refuse, such as a demotion, negative performance results, or even a loss of employment. Job seekers can also be recipients of this kind of harassment from a person with hiring authority. For example, the person hiring may promise to make sure that they get the job in exchange for sexual favors, or insinuates that getting the job depends on what they're willing to do for it. For example, Jane is interviewing for a job at a mortgage company. Her interviewer puts his arm on hers and rubs it suggestively, then lets it linger. Jane is confused and brushes his hand off. He puts it back and tells her, "I thought you wanted this job badly." Hostile work environment. This type of sexual harassment occurs when an employee is subjected to conduct that is so persistent and severe that their work environment becomes intimidating, uncomfortable, and offensive to the point that it affects their performance. Hostile work environment harassment does not always have to be sexual in nature. It can also be subjected to one's religion, disability, race, physical appearance, sexual orientation, or gender. Unlike quid pro quo, the perpetrator of a hostile work environment is not necessarily a person with authority over the victim. It can be anybody, including coworkers, supervisors, managers, and other third parties. This type of harassment is usually repetitive, happening often, and over an extended period. In a hostile work environment, the victim's employment status, salary, career trajectory, bonuses, and responsibilities are typically not affected. An example of hostile work environment harassment. Mary and John are both supervisors in a marketing company. 3 times a week, they're required to visit various field offices using the company car. On the car ride, John relentlessly discusses his sexual exploits and even asks Mary about her sexual experiences. He also hints that he would like to show Mary some stuff. Mary has told him to stop as it makes her uncomfortable, but John persists. Mary has started dreading the field trips and has even started making excuses as to why she can't go. This is negatively impacting her performance, and her managers getting concerned. Hostile work environment harassment can also be experienced by someone who is not the intended recipient. For example, Jane is the only woman in a department of 5. Their manager, Lucy, is also a woman. Jane's male coworkers dislike Lucy and often make comments such as, "Women are weak," or "This woman is clueless," or "It must be that time of the month," in reference to Lucy. While Jane is not the intended recipient, she's experiencing a hostile work environment based on the hostile, gender-based comments made towards another woman
So now we
in her
should have a
presence.
good understanding of the difference between quid pro quo and hostile work environment types of sexual harassment. So be aware that the employer can be held vicariously liable for the harassment by an employee. So those examples that were given in the video. So when these 3 men that were working with that woman were saying inappropriate comments, creating a hostile work environment, the employer can be responsible, can be vicariously liable if the employee, if the woman in that example can prove that the employer was negligent in either discovering the conduct, so should have discovered the conduct, or failing to respond to a complaint made to a supervisor. So if this woman had complained and the employer never did anything about it, failed to respond, that could be a grounds for vicarious liability. So when there is unlawful discrimination, Title VII provides employees who are victims of unlawful discrimination with different kinds of remedies. And we've talked about remedies in other portions of the class, and these are the remedies available here to a victim of unlawful discrimination. The first is an injunction, so requiring the employer to take certain actions to prevent future harassment. So a judge would order that requirement as an injunction. Reinstatement, so orders the employer to give the job back to the terminated, let's say that was what happened to the terminated employee who brought the unlawful discrimination claim. The next is compensatory damages. So the employee can claim out of pocket expenses incurred because of this. So let's say for job searches, for medical expenses. There can also be compensation as for emotional harm, mental anguish, loss of enjoyment of life, and different results because of this unlawful discrimination, different kinds of damages that have been sustained. Also, punitive damages, which we've talked about before, are available when the plaintiff proves that the employer acted with malice in retaliation or with reckless disregard to the employment discrimination laws. So it's hard to get punitive damages, but it is available in these situations. Okay, so we're going to now shift to the FLSA, which is the Fair Labor Standards Act, and it provides protections to certain kinds of employees regarding wage and hours worked. So it is intended to cover all employers engaged in interstate commerce, so many employers. So its main provisions, and we'll look at these four, is the minimum wage, the maximum 40-hour work week, overtime pay, and restrictions on child labor. And the regulations are administered by the U.S. Department of Law. So let's take a look at these. So we said the first of the provisions that we're talking about in the FLSA have to do with the payment of minimum wage. So 2025 federal minimum wage is $7.25. And you may say, well, how come it just seems like it's so much higher? Well, states, and we're in New Jersey here, are permitted to set a higher minimum wage level for employees working within the state. And New Jersey's current level is $15.49, which is relatively high. The Portal to Portal Act is what provides guidelines for what constitutes compensable work. So work that should be compensated for, and this wage requirement is required under that, and provides broad exceptions to the wage and hour requirement. So unless the activity is integral and indispensable to the principal job, employees are not entitled to compensation. So you're entitled to compensation. The activity is integral and indispensable to their principal job, but not for other activities. So time spent by an employee traveling to and from the place of the employee's job, like this woman right here, that would not be entitled to compensation for that. Time spent by an employee on activities performed before or after the principal activities in a workday. So like punching the time clock, if that even exists anymore, it's probably electronic, they would not be entitled to compensation for that time. Let's say cleaning up before or after work. It depends. It depends on the job and whether or not that is integral and indispensable for the principal job. So this Portal to Portal Act was passed in 1947, and I'm going to show you this video. And the president of a payroll company does a nice job explaining the Portal to Portal Act. So we're just going to watch part of this.
Hi, I'm Charles Reed, president of Get Payroll. As an employer, you must track the hours that your employees work. Then you are legally required to pay them for all the time worked. The FLSA, Fair Labor Standards Act, administered by the Department of Labor, sets forth the requirements for the federally mandated 40-hour work week. However, the Congressional Portal to Portal Act, first passed in 1947, modifies the FLSA in several ways, including but not limited to the following. Now, certain activities are not considered working for compensation, such as traveling to or from work, or engaging in incidental activities before or after work. But the U.S. Supreme Court has ruled that the Portal to Portal Act requires paying employees for activities that are integral and indispensable to an employee's principal on-the-job actions. An employee cleaning up before or after work is not normally considered work time for pay. However, if the work includes working with dangerous materials, washing up may be integral and indispensable for safety purposes. If so, the employer must pay the employee for that time because it involves worker safety and is therefore compensable. Now, punching in or out of work, waiting in line for a paycheck, searches of workers for safety or anti-theft screening are not considered working time that the employer must pay the employee for. But if an employee is required to attend a training class on any subject, the employer must pay for that time. Now, an automated time and
So
attendance
if you're
tracking
considered a
system
non-exempt
makes for
employee under the
fast,
FLSA,
accurate
we know
payroll
that there are
preparation.
certain rules that apply. And the one that we still have to talk about is the maximum hours and overtime. So we talked about the minimum wage, the maximum hours and overtime pay, and then we'll talk about the restrictions on child labor. So the FLSA sets the standard work week at 40 hours in a 7-day period. And under the FLSA, employees are entitled to overtime compensation. So hours worked beyond the standard 40-hour work week. And the overtime pay is the hourly base rate of the employee times 1.5. And the FLSA assumes the base unit of time of 1 week. So if someone is working a 40-hour week, typically, and they, let's say, work overtime 5 hours, so they would receive 1.5 times their pay for those additional 5 hours in addition to their hourly pay times the 40 hours that they work. So we need to determine sometimes if an employee is an exempt employee. So employers are not bound by the FLSA for employees classified as exempt employees. So they're exempt from the FLSA requirements. So they would be exempted from overtime pay, exempted from the minimum wage requirements. And the duties test is what your book talks about with regard to making that determination as to whether or not someone is an exempt employee. So we look at the education, the skill level, certifications required for that particular position, the salary level, the compensation method, amount of physical labor required. So is this a warehouse worker who would likely be non-exempt, or is it something else? The amount of repetitive tasks. So would it be some kind of unskilled task over and over again, like a mailroom worker? That would probably fall into the non-exempt. Degree of supervision required by the employer. So examples of exempt employees would be, as we said, they have certain skill levels, salary levels, and other compensation methods. So typically, professionals who are attorneys, doctors, teachers, accountants fall into those categories. If it's a supervisor type of employee, they probably as well would be exempt. Management employees, computer engineers, employees who require certification, like a dental hygienist, would also fall into the category of exempt employees. All right, so let's just take a quick look at this chart, and you can see it kind of breaks down exempt versus non-exempt employees. Can take a look at that. All right, so it is important for employers to make sure that they don't misclassify someone as exempt when they're not, and vice versa. So here is the thing, the consequences and penalties can be pretty severe for employers. So unless the employee is clearly exempt from coverage, clearly exempt, and those requirements under the FLSA do not apply, then the employee should be classified as a non-exempt employee under the FLSAA until the time when the employer has legal assurances, is sure that the employee is exempt. So you don't want to classify as exempt unless you're definitely sure. Coverage by the FLSA, keep in mind, is not necessarily determined by job title. We're going to look at the duties, right? That's why it's called the duties test. So some employees have job titles that include the word executive, but they still qualify for coverage, like executive secretary. All right, child labor laws also under the FLSA imposing restrictions on hiring workers under 18 years of age. Children in certain roles, family agricultural jobs, child actors, aren't subject to the FLSA restrictions, but there are some educational standards, educational requirements to be met. Every state has a child labor statute to supplement the federal law. So here are some of the child labor restrictions to keep in mind. And you may have had to deal with these when you were younger, or you know someone who does. That based on your age, there's certain restrictions listed here that have to do with children working. Okay, agency law. Be aware of this term. Agency is this legal relationship in which parties agree that one party will act as an agent for another party, called the principal, subject to the control of the principal. So the principal may be the owner of the business, the manager in the business, and the agent would be the employee working under this person. Agents are classified into one of three broad categories: employee agents, as we just talked about, independent contractor agents, and gratuitous agents. And this matters because the liability of the principal depends on what that agency relationship is. So the first, employee agent, okay, so let's say we're talking about a law firm, so a secretary at a law firm. They're authorized to transact business on behalf of the employer principal, so on behalf of the attorney in the firm, of the law firm itself. So the principal is generally liable for the actions and omissions if it is an employee agent. Now, an independent contractor agent, so let's say the law firm hires as an independent contractor a photographer who's used to take headshots of the people who work within the firm. Now, this independent contractor is not considered an employee and has no legal protections such as minimum wage and overtime compensation laws. And also, the principal is generally not liable for the actions and omissions because it is an independent contractor as opposed to an employee agent. Then we've got gratuitous agents. So let's say someone decides that they're going to come and help, let's say, take pictures of the headshots of the attorneys within the firm, and they're not receiving any compensation. So these gratuitous agents, generally the rights and duties are not the same as those of paid agents, except that the duty of care is not as great. So keeping that in mind. All right, that was it for employment law. I hope you enjoy the rest of your day. Thank you.